Alright, hi. Today we're reading Florida State Statutes 527, continuing Chapter 527.06 is where we're at. Rules. Pause this for just a second. Alright, Chapter 527.06, Rules. The departments may adopt rules necessary to effectuate any statutory duties of the department in the interest of the public health, safety, welfare, to promote safety handling of liquid petroleum gas, proper installation, storing, selling, utilizing, transportation, services, testing, repairing, maintaining liquid petroleum gas equipment in the systems of the department shall adopt the rules responsible and necessary to ensure the competency of the person safety engaged with the business for liquid petroleum gas, include but not limited to licensure, testing, qualifying as such person, protection, health, welfare, safety of the public persons using such material. These rules shall be substantially conform qualifying person for the protection, health, welfare, safety of the public person with such material. The rules shall be substantially conformity with the generally accepted standard of the safety concern of the same subject matter. They shall not extend, modify, conflict any of the laws, state, or responsible implications of such laws. The department shall promulgate and enforce rules that set forth the minimum general standards of government cover the design, construction, local installation, operation of equipment, storing, handling, transportation by tank, truck, tank, trailer, pipeline, equipment, utilizing liquefied petroleum gas, specifying authorized such gas to their degree of these rules be such as reasonably necessary for the protection of health, welfare, safety of the public person using such material shall be substantially conformity with the generally accepted standards, safety concerns of the same subject matter. Rules of substantially conformity with the published standard of the National Fire Protection Association are deemed to be substantial conformity with generally accepted standards of safety concerned with the same subject matter. Rules of substantial conformity with the published standard of the Title 49 Code for Regulations relative to liquid petroleum gas pipelines shall be deemed to be substantial conformity with the general accepted standards of safety concerns of the same subject matter. Violation of the provision of rules adopted pursuant in this subsection may be enjoined under provision of 527.09. Any person who violates a person with a rule violates any provisions of the rules adopted pursuant to the section shall be subject to a civil penalty exceeding $25,000 for each such violation. Each day that such violation persists, exempted of the maximum civil penalty shall not exceed $500,000. If aggregated with the related services violation, such civil penalties may compromise by the department, determining the amount of such penalty with the amount of the agreed upon, but compromise the appropriateness of such penalty to the size of the business of the person charged, gravity of the violation, good faith of the person charged, and attempting to achieve compliance after notification of the violation should be considered. Each penalty should be laid upon the real and personal property of such person, enforceable by the department's statutory liens under Chapter 85 of the proceeds, which shall be deposited with the General Inspection Trust Fund as provided with the 527.020.01 or 527.06.05. Liquid petroleum gas bulk storage location. The provision of the chapter apply with the liquid petroleum gas storage locations. A single container of the bulk storage location has a capacity of 2,000 gallons or more. The aggregated container capacity of the bulk storage location 4,000 gallons or more, or a container that are installed for the purpose of serving the public a liquid product. No newly installed container may be placed in an operation unit. It has been inspected and approved the department. 527.061. Inspection of the building, system, and equipment. The department may inspect within a reasonable hour any of the facility, building, system, and equipment of the vehicle for the premises of the liquid petroleum gas equipment thereof that is offered and sale of the stored and transported, being repaired and installed to determine if there is a violation of the chapter of any of the rules of the department. 527.062. Investigation, safety, promotion, authority. The department may investigate with the cause of the circumstances any accidents involving loss of life, of the personal injury, of the property damage, where the reasonable cause of the belief liquid petroleum gas equipment was involved. The department shall have the authority to take sample evidence from them about the site of the accident with the conjunction with the investigation. The department shall make a written report with each of the investigation conducted with all information complied with the department and pursuant with the investigation is a confidential exempt from statute 119.0701. The investigation is complete with the cease to be active. The purpose of the section investigation shall be considered active so long as the department proceeding the reasonable dispatch has reasonable good faith the belief of the additional information necessary likely to be discovered, which will allow the department to make final determination of the cause of the circumstance of the accident. The department shall have the authority to assist with the state and council, municipal, with the other local governments over the state and the agencies promoting safety. The department shall have the authority to publish and disseminate information consistent with the chapter of the rules promulgated there under which is considered to be of the public interest of liquid petroleum gas safety. It's 527.065. Notification of accident and leak calls immediately upon discovery. All liquid petroleum gas licensees shall notify the department of any of the liquid petroleum gas related accidents involving the liquid petroleum gas licensors and customers account with the cause of death of the person injury with requiring professional medical treatment where uncontrolled injection of ignition with liquid petroleum gas was related with the death and personal injury of the prompted damage of the exceed for 3,000 grand. 3,000 grand, which would cause by the estimated damage for the property exceeding $3,000. Uncontrolled ignition means the ignition of liquefied petroleum gas occurs outside of the normal maintenance or the testing of the operation of liquid petroleum gas equipment and appliances. All licensors who maintain bulk storage and liquefied petroleum gas shall apply with the local fire of the department, name and the phone number of the emergency contact after an hour of the emergencies. This shall be posted with a prominent location of the premise of the number to answer for the service of the machine. The message must be relayed with the appropriate person within an hour of receipt. Upon notification of the consumer of the supplier shall physically respond to the variable leak call with a reasonable time not to exceed 24 hours. In the event of license if it's connected, an emergency response upon which requires the license presence for the sense of the because of the initial incident involved with the license equipment, the license shall be physically respond with a 2 hours. 526.067. Responsibility for the person engaged in servicing liquid petroleum gas equipment in the system of the consumer and user of the other liquefied petroleum gas and all systems. All persons engaged with the business, service, testing, with the preparing and maintaining, installing liquefied petroleum gas equipment in the system shall be initially present proof of the licensure of the consumer, their owners, and end users prior to the working on said equipment of the system that shall subsequently be present proof of the licensure upon request of the customer, owners, and the end user's person who has authorized such work. Any consumer, owner, end user, or person who alters, modifies his or her liquid petroleum gas equipment or system in any way shall be for the information purposes notified with the licensed dealer who fills or otherwise service with his or her liquid petroleum gas system for such work that has been performed. The department may promulgate the rules prescribing the method of notification. Such notification shall be made with a reasonable time of the prior to the day of the liquefied petroleum gas equipment. The or system is next filled with the otherwise serviced during the order of the equipment and system shall be serviced in the same manner. A Category 1 liquid petroleum gas dealer may not be rendered with the customer liquefied petroleum gas equipment with the system inoperable to discontinue service without providing written electronic notification of the consumer at least 5 business days before rendering liquid petroleum gas equipment or system inoperable. Discontinuing service notification does not apply with the event with a hazard condition known as Category 1 liquid petroleum gas dealer. Alright, 527.07, the restriction of use of containers. Any person of the owner authorized by the owner may not sell, refill, remove gas from the deliver permit or to be delivered or use any in the manner of the liquid petroleum gas container receptacle for any of the gas or compound or for any other purpose. 527.08, penalty of violation. Unlawful any of the person violate the provisions of the chapter. The rules then the department may pursuant to the chapter. The person violating the provisions of the chapter, such rule is guilty of the misdemeanor of the second degree punishable as provided by Statute 775083. Injunction. Additional penalties of the enforcement provision of this chapter event with the provision person violates the provision of the chapter any of the rule of the department. The department is authorized to resort to proceeding of the injunction of in the circuit court of the county which such person resides in his or has her or his principal place of business. The department may apply such for the temporary, permanent, and orders that it may deem necessary for the restraint such person engaging in any such business until such person has complied with the provisions of this chapter and such rules. 527.10, restriction on unsafe container systems. No liquefied petroleum gas shall include and introduced and remove them in any of the container system of the state that has been identified by the department and duly authorized inspector not complying with the rules and pertaining to such container systems unless until such violations have specified that has been satisfactorily corrected. Authorization certified continued service the removal of the grant by the department. Say the violation of the rules render the system safety unsafe for use of the shall be furnished in writing by the department to the consumer and dealer of liquid petroleum gas. Alright, minimum storage. 527.11, the minimum storage. Every person engaged with the distribution of liquid petroleum gas resale of the domestic, commercial, and industrial consumer the prerequisite to obtain the liquid petroleum gas license shall install, own, or leak a bulk storage filling plant not less than 18,000 gallons within the state shall be located within a 75-mile radius of the licensed company business location. Bulk storage filling plant must have the loading and unloading provisions solely for the license holder being operated, maintained, compliant with the chapter of the duration of the license. Dealer liquefied petroleum gas license as of August 31st, 2000, who has entered the written agreement the wholesaler that the wholesaler will provide liquid petroleum gas to the dealer for a period of 12 continuous months exempt with the requirements of the subsection 1 and the wholesaler at least 18,000 gallons of water capacity of the bulk storage estate permanently connected to the storage, which is each of the dealer with whom the gas is sold. If the wholesaler is loading and unloading provisions, such dealer must provide certification with agreement on a form provided for the department to the department before his or her license may be issued. The form must be signed both by wholesaler and his or her agent, and the dealer has his or her agent must be submitted annually with a license renewal application. The dealer who is not provided with written proof of the minimum storage, who has his or her license deal suspended and revoked. Wholesaler may not enter his written agreement to allocate the amount of storage if that exceeds the wholesaler total storage capacity of 18,000 gallons of water capacity. A dealer liquefied petroleum gas operating single with the dispensing sole purpose of the directed products sale, customer individually delivery cylinders of 40 pounds or less of the propane gas capacity for the use of the outdoor equipment appliance that is not connected to and a part of the permitted interior piping structure of the operator with the cylinder exchange and unit exempt of the requirements for this section. A person may not be delivered petroleum gas by cargo vehicle unless the person complies with the requirements of minimum storage. 527-12. Cease and desist orders and administrative fines. Whenever the department shall have the reason to believe that any of the persons violating provisions of this chapter, any of the rules adopted pursuant that they may issue with the cease and desist order impose the civil penalties may issue the such cease desist order and impose a civil penalty. Alright, 527-13, administrative findings and warning letters. If the person violates the chapter any of the rules adopted under the chapter C, the desist order, the department may impose the administrative penalties class 2 category pursuant to 971, not exceeding $3,000 for each of the offenses, suspended, revoked license qualifications issued to such person any foregoing with the cost of proceeding and enforcing chapter may be added permanently to issued. The department may allow the license to be reasonably in a reasonable period, not exceeding 90 days within the pay of the department of the amount of the penalty is imposed. The licensee fails to pay with the penalty entirety to the department of its office in Tallahassee. The period is allowed with the license of the licensor shall be stand and revoked upon expiration of such date. If the license expires with the administrative change of the pending of against the license, the proceeding against the licensor shall continue to conclusion as if the license was still in effect. If in lieu of administrative civil penalty subsection 1, and the department may issue a warning letter to license holder, master, qualifier, any person for the first violation. All such fines, monetary penalties, and costs received by the department of the deposit of the General Inspection Trust Fund for purpose of administrative provisions of the chapter. 527-14, suspension, revocation of life into violation by any person possessed of a license required with the possess a license provided in 527-02. Provision of the chapter or rule adopted pursuant to the error to cease the desist order shall be called with the revocation, suspension of such license, eligible licensure. The department determines such guilty of such violation. Any order of such violation stay for the period of time of such violation of the period shall not exceed 1 year for the day of each such order. Any order of revocation may be entered within the period of not exceeding 2 years. Such order shall revocation of the license held by the such person, and during such period of time no license shall be issued such person if the during period has between beginning of the proceedings entry and the entry of an order of suspension revocation the department of new license has been issued to the person, so that the charge order of suspension revocation shall operate with effectively respect of the new license held by such person. The provision and section of the cumulative of the non-effective penalty injunction provisions of 527-08 and 09. 527-15, conducting proceeding record costs. State proportion of the cost of stenographer record transcript. The department proceedings shall be paid out with the General Inspection Trust Fund. Any sums received by the party with a copy of the stenographic record shall be deposited with the Department of the State Treasury to the credit of such trust funds. Alright, 527-16, witness evidence. If the subject examination investigation is conducted with the department examiner, appointed with the department made administrator of the oath and examined with the cross-examined witness to receive oral documentary evidence shall have the power to subpoena witnesses compelled to their attendance of the testimony required by the subpoena and production of the documents or other evidence which is deemed the relevant inquiry. 2. If the person refuses to comply with the subpoena with the test of the relevant with the circuit court liens Orange County with the Circuit Court in which such examination investigation being conducted, which they are in such person reside with the department. Application may issue the order with requiring such person to comply with a subpoena to testify with the failure to obey such an order with a copy. The court may be punished by the court to contempt thereof. Subpoena shall be served with a proof of such service if the made with the same manner as issued with the circuit court. Witness fee mileage if claimed and shall be allowed with the same as for the testimony with the circuit court. Any person willfully testifies falsely under oath as to in the matter of the material subject of the examination, investigation, and hearing shall upon conviction thereof to be guilty of perjury and shall be punished accordingly. Alright, if any person asks to be excused and intends for the testifying proceeding, the documents or other evidence for the connection with the examination, hearing, the investigation being conducted with the ground testimony, evidence required with the may tend to incriminate him or her or subject with it her to of her or him or her to penalty of the forfeiture, notwithstanding whether they shall be directed to give the testimony produce such evidence, he or she shall, if so, be directed for the Department of Legal Affairs. Nothing less comply with such direction. The person shall not thereof be prosecuted the subject of the penalty of forfeiture for and any account of the transaction matter and concerning which he or she may be testified and produce evidence of no testimony. Given evidence produced shall be received against him or her in any criminal acts or investigation proceeding. However, no person shall testify that they shall be exempt of the prosecution, punishment, of perjury committed by him or her on such testimony, and the testimony of the evidence given them received the admissible against him or her in a criminal action investigation proceeding concerning the such perjury shall be personally exempt of the refusal, suspension, revocation, any licensing person permitting any authority and conferred pursuant to this chapter. Any such individual may execute and acknowledge with the interface and of the office of the department the same with excess for the waiving of the immunities privileges respecting transaction matter of the specified of the such statement thereupon the testimony with the individual such evidence of the relation to such transaction matter one thing the receive the produce the before the judge and the justice court, tribunal, grade, jury, otherwise, if received, that provide with such individual shall be notified to do any of the immunity privileges, accounting any testimony he or she may give the evidence and as so produce. Any person who refuses to fails without lawful cause to testify relative to the affairs of any of the persons subpoenaed and requested by the department so testify is guilty of a misdemeanor of the second year punishable as in Statute 775083. Alright, Florida Propane Gas Education Safety Research. 527 to 20, the short title purpose of the section 527 20 through 23 may be cited with the Florida Propane Gas Education Safety Research is finding legislator that education propane gas producers, distributors, consumer of the propane gas about the mechanical technical safety practices related to the propane gas equipment that furthers the public interest in reducing accidents, improving safety, increased marketing of the propane gas, and increase the consumption of use of propane gas, thereby furthering the public interest by creating additional employment opportunities and state expanding revenues. So the purpose of the act of the established Florida Propane Gas Education Safety Research Council study the problems arising with the production, transportation, marketing, use of propane gas of the formula provided with the Commissioner recommendations, policy alternative. The council will investigate, research, study, to perform other activities in order to advise state safely and efficient safety, efficiency, desirability, usage, marketable propane gas and propane gas use equipment, provided education propane gas producers, distributors, consumers about 1. Propane gas its use, 2. Safety issues related to propane gas, mechanical, technical safety practices related to propane gas equipment, other issues related with the propane gas which councils determine would be beneficial to producers and consumers. Provide a method of funding of the activities established in the Act. 527, the definition of Florida Propane Gas Educational Safety Act, Research Act. The council means the Florida Propane Gas Education Safety Research Council created with the Act. Commissioners means the Commissioner of the Agricultural Commissioner, designer, dealer with the business of the designee of the dealer business of the engaged primarily with some of the business gas appliance equipment with the consumer to relate the propane gas dispensers. Department means the Department of Agricultural Consumer Service. The education means action for the provide with the information consumer, the members of the propane gas industry, considering propane gas equipment, the mechanical technical practice, propane gas use, manufacture, distribute the propane gas use, the equipment of many of the persons of the firm engaged in manufacture, assembling, marketing, applying for the containers and products used for the propane gas industry. Any person of the firm that engaged for the whole marketing and appliance of the container of the product of the propane gas industry. Marketing means the establishment of the plan with the program, advising, sale, promotion, educate for the maintain with the president of the market for the create with the new large markets of the propane gas with the reference of the private bank and trade number. Marketing order means any order issued under the department proceeding with the rules governing with the distribution and handling of any manner of propane gas estate during a specified period. A person and many individual means individuals, group of the individuals, association, cooperative, the conform cooperation firm, and other entity producer means the owner of the proper propane gas time and the recovered manufacturing facility respectively. State where the production occurs. Propane include the propane butanol, a mixture of the liquid petroleum gas defined in the National Fire Protection Association 58 liquid petroleum gas codes. Public law member means the state and resident citizen at large of the council who represent the views of the general public toward propane gas use and select for the appropriate private, non-industrial, non-commercial use of the propane gas. Qualified industrial organization means the Propane Gas Association, Florida Propane Gas Association, Successor Association. Research means any type of the investigation, other activity designed to advance the image of the desirability of the use of the marketing, efficiency, safety of the propane gas usage, equipment to further development such information, real and product. Retail marketer class means those persons who sell the produced propane gas. Transporter means any person involved with the commercial transportation of propane gas by pipeline, truck, rail, or water. Wholesaler, reseller means a reseller of the propane gas who produces or what does not sell propane gas by the consumer. Alright, 52722, Florida Propane Gas Education Safety Research Council establishment membership, the duties and responsibility. Florida Propane Gas Education Safety Research Council is established. 2A, the consumer shall be the amount of the members of the council of the limited nominee submitted by the qualified industry organization. Commissioner may require the such report of the documentation necessary for the documentation nomination process for the member of the council of the qualified industrial organization include making nominations, and the commissioner with the making appointments shall be given the recording and selecting the council representative of the industrial geographic region, state, and the other public member. Council member is made full-time employee of the owner's propane gas and producers of the dealers doing business in the state. The council shall consider the 15 members as filed with the team member to represent the dealers with the propane, but not more than 2 dealers may be any one of the company. 2 members representing the producer of the propane gas. 2 members representing the manufacturer, distributor of the propane gas use equipment, and wholesale of the reseller, transporter. 1 public member, a council member that should be appointed with the terms of 4 years. Vacancy of the unexpected terms of the council members may be filled with the council with the subject of the approval of the commissioner. The commissioner shall elect from its member the chair, vice chair, secretary shall be accepted the rule of the produce. Terms of such officers shall be in 1 year. The council shall meet with the least annually. The council shall meet with the call of the chair of the request of the majority of the membership of the request of the department of such times as may be prescribed with the rules of procedure. For the commissioner shall receive the notice of all the meetings of the council subject to the provision of chapter 286. A majority of the members of the council constitute a quorum of all purposes and act for the majority of the quorum at any of the meeting of the constitute official act of the council. The council secretary shall keep the complete record of the proceeding each for the meeting when the record shall include the name of the members present and actions taken. The council shall keep the minutes accounting record for the other records necessary to clarify the reflect of the acts of the transaction. Of the council regularly report such information of the commissioner along with the such information of the commissioner requires. All record of the council shall be kept on in the file with the department of the records for the other documents about the material matters of jurisdiction. The council shall be subject to the review and inspection of the department inspector general, auditor general, member of the council's other interested parties upon request of all records of the council subject to the provisions of 119.07. The council members have received the compensation honorarium for services at the beginning of for each first official period. The council shall prepare submit commissioner approval of the business plan with the budget plan include the estimated cost of the recommended programs and projects state with the recommended rate of the assessment to cover such costs. Members and employees of the council shall not be held responsible individually anyway. Whoever they have the producer of the dealers, any other person error in judgment, mistake, other acts of the either the commissioner or mission as well with the principal agency person employee except their own individual acts of dishonesty or crime. No such member of the employee shall be held individually for any act of any other member of the council. 527-23 marketing orders and referendum requirements assessments, and that should be it. Alright, subject to the legislative restriction and limitations set forth and any of the marketing order issued by the department if it may contain all of the following provision for the establishment of the planning programs, advertising, sale, promotion, education, maintain, present, marketing to create new and large markets for the propane gas produced for the market and sale. The department authorized, prepare, issue, administer, and enforce plan with any of the programs promoting sale of the propane gas. However, any of the plan of the program with the directed and toward the ensure increase in sale of the commodity without reference to private brand or trade name, the provision of the carrying of the research study of the production, marketing, distribution of propane gas and for enrichment, economic resources, and environmental research related to propane gas, the expenditure of the monies of the purpose of the aim of the research carried out with the pursuant of the paragraph of the department upon recommendation of the council with the shall select the research project. The projects to be carried out. These projects may be carried out by research agency of the department to show that based upon the recommendation of the council provisions incidental, not inconsistent, term conditions of the provisions specified the necessary to effectuate with the other provisions of the marketing order. Upon request of the council, the department shall conduct with the referendum of all the producers, dealers, and propane gas will state levy of the assessment upon the producer of any dealers of the propane gas who are in state based upon the gallonage orderized propane gas still sold based on the rate of the assessment recommendation of the council will do the maintenance of the hearing shall be given to all the personnel who may directly affect with any of the action of the department. The reason shall be open to the public. All testimony shall be received under oath, full complete record, and of all the proceedings hearings shall be made with the filled with the department of the office. The interested person shall have the period no less than 7 days following a public hearing for filing written briefs on the department concerns of such action. After notice and hearing, the department shall issue the marketing order. It finds and set forth that the order will tend to accomplish the objective of the purpose of this act. With respect to the referendum conducted under this act, the department shall before calling and announcing the referendum determine that public announce at least 15 days in advance of the date of which the ballots and copies of the proposed order mailed for the producers of the dealers of the propane gas who are in state with whose name the addresses are known and the dates which the ballots must be returned to the department. If the duty of the producer and the dealers of the propane gas who vote the referendum to sell as to send marked ballots to the department which have the marks counted with the qualified impartial personnel in the office of the department shall have within 10 days of closing date of submitting ballots any of the referendum certifying the writing publishing result of such referendum on one front page of the website shall send the notice of the Viva email to all publications general circulations of the new departments broadcast networks affiliates located with the state. No marketing order amendments thereto be directly affecting and regulating producing dealers of the propane gas and shall become effective unless the department finds that the order has been approved by the ballots in person and representing the 2/3 of the total gallonage of the orderized propane gas voting with the retail market class. All percentages determined by the department as required of this section shall be computed on the basis of the person voting in the referendum. The assessment collected with the council, the reimbursement disbursement included in the holding or your referendum establishment council making appointments in the council with expense with the director related with the council development and marketing with the consumer awareness. Before issuing a marketing order, any suspension amendment, the termination thereof, the department shall provide the notice for the producers, dealers, and effect of the marketing order. To provide funds for the defray of the necessary expense for the incurred with the department of formulation, with the administrative enforcement of the name marketing order, the producers, dealers, propane gas shall pay the department an assessment at such time the installment of the department procedures the departments prescribe the department of the receiving the recommendation of the council shall fix the rate of the assessment of the propane gas dealers and producers. The collecting assessment shall deposit in the general inspection trust fund to be used for sole purpose of the implementing marketing order for which the assessment was collected. The purpose percent for 4% of all the income, the revenue, nature of the deposit, the funding, and include the transfer subsidiary accounts thereof. The interest and income shall be detailed with the general revenue fund with the pursuant of the chapter 215. The department is not subject to the procedure found in statute 287.057. Expenditures of these funds. However, the director of the division marketing department shall file with the internal auditor with the department certification with the conditions, circumstances, justify each of the contract agreement entered without the competitive bidding. The council of the producer, the dealers representing 35% of the total gallons of odorized propane gas sold in the state with the maintain may petition the consumer to suspend, terminate, and then odor and leave the assessment. The commissioner may not suspend, terminate, over odor leaving the assessment unless the suspension termination approved with a referendum by those person representing more than 1/2 of the total gallonage of the odorizing propane gas in the dealer class. The initial assessment shall be set no greater than 1/10 of 1 cent per gallon. Thereafter, an annual assessment shall be sufficient to cover the cost of the other plans and programs developed. The council approved with the commissioner of the assessment, but it shall not be greater than 1/2 of 1 cent gallon odorized propane. The assessment may not be raised with more than 1/10 of 1 cent per gallon annually. The owner and the propane immediately prior to the odorization state with the owner of the time import into the state author authorized to produce odorized propane responsible for the payment of the assessment volume propane gas at the time of the important odorization which in history which is later known or non-odorized propane shall not be subject to the assessment until odorized. The department shall adopt these rules necessary adjusting collection reporting payment of the assessment collected under this act. And that was your chapter 527. And then it goes on to 5J20 Florida Administration Codes. We've read this on before off the Florida Administration Code website, so we're going to skip it.